Welcome to Do It for the Case Law for Wednesday, August 12, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today's docket features 48 federal appellate opinions across 8 circuits. We begin with the Supreme Court and Constitutional Law beat, followed by coverage of criminal justice, including drug trafficking, firearms, fraud, and violent crimes. We also dive into civil rights matters involving Section 1983 claims, employment disputes, housing issues, and habeas corpus petitions under Title 28, Section 2254, and general federal habeas relief. The business and labor segment covers bankruptcy, securities, and torts, while immigration and government topics include administrative agency reviews, environmental law, and Social Security appeals. Please subscribe to stay updated on daily federal appellate analysis. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. I have 18 criminal justice cases from the 10th, 11th, 4th, 6th, 7th, 8th, and 9th circuits to report. The disposition roll-up shows 9 affirmances, 1 dismissal, 2 reversals, 1 vacatur remand, and 1 split outcome of affirmed in part remanded. Starting with the 10th Circuit, the court reversed a summary judgment in Walden versus the City of Duncan and Officer Archer, holding that an officer could act under color of state law when arresting an Indian suspect on tribal land without first definitively determining tribal status. The 11th Circuit affirmed drug trafficking convictions for Hanson Alexander Clark regarding conspiracy to distribute methamphetamine and fentanyl, and also upheld Robert Clark's supervised release revocation sentence after he failed to object at the district court level. Moving to the 4th Circuit, the court issued unpublished affirmances in cases involving Daquan Tyree Payton and Jacqueline Brewster for drug distribution offenses. In a more detailed opinion, Colby Joyner's healthcare fraud convictions and 72-month sentence were affirmed. The court ruled that excluding internal compliance documents was proper under Federal Rule of Evidence 403, and that quashing witness subpoenas was justified by their Fifth Amendment privilege claims. Over in the 6th Circuit, Kyle Wagner's pretrial release order was reversed because the government met its burden to prove by clear and convincing evidence that he posed a danger to the community based on online calls for violence against federal law enforcement. The 7th Circuit affirmed Daniel Betty's 264-month sentence for child exploitation offenses, rejecting arguments about double counting under the guidelines. In contrast, Christopher Lloyd's sentence was vacated and remanded because his prior Indiana conspiracy conviction did not categorically qualify as a crime of violence under the sentencing guidelines due to the statute criminalizing unilateral conspiracies. In the 8th Circuit, Amir Kalomo Mulamba's motion to suppress cell phone evidence was affirmed based on probable cause and exigent circumstances regarding solicitation of a minor. Xavier Murray's appeal was dismissed for failing to comply with his plea agreement's contemporaneous objection requirement. Andre McCoy's suppression motion was affirmed, but the case was remanded for a limited purpose regarding a sentencing condition conflict. David Raphael Walker's conviction as a felon in possession of a firearm was affirmed, and Levi Miller's supervised release revocation sentence was upheld. Finally, the 9th Circuit affirmed Volodymyr Kugita's convictions for operating a Ponzi scheme known as Trend Sound Promoter across multiple fraud counts, finding no reversible error on jury unanimity or evidentiary grounds. The court also affirmed summary judgment for the City of Tacoma in Stewart versus the City of Tacoma, ruling that the plaintiff failed to prove municipal liability under Monell. Back to you, David.
Thanks, James. Now for civil rights and employment discrimination, let's turn to Aisha.
Thanks, David. We have 10 cases in this civil rights and employment block. The disposition roll-up is 6 affirmances, 1 affirmed in part and reversed in part, 1 reversed and remanded, and 2 split outcomes where the court affirmed some claims but reversed others. Leading with the reversals and splits, over in the 7th Circuit, the panel affirmed summary judgment on a Fourth Amendment claim regarding an unlawful frisk but reversed summary judgment on a claim that a traffic stop was unconstitutionally extended. The court found genuine disputes of material fact about whether specific observations provided reasonable suspicion of a drug offense, allowing the extension claim to proceed under the standard in Rodriguez versus United States. In the 9th Circuit, the court affirmed in part and reversed in part a dismissal involving a job offer rescinded by the Department of Homeland Security. The appellate court held that the Civil Service Reform Act does not bar judicial review for applicants hired through private contractors, so the district court erred in dismissing the Administrative Procedure Act claim sua sponte. However, the Title VII claim was affirmed as dismissed without leave to amend. Also in the 9th Circuit, the panel reversed and remanded a qualified immunity denial involving the fatal shooting of Daniel Luis Valdivia by police officers. The court held that retrieving a gun and moving it toward officers constituted an immediate threat, making the force objectively reasonable under the Fourth Amendment, and finding no clearly established right violated on the due process claim. Turning to the affirmances. In the 10th Circuit, the court affirmed dismissals of 2 pro se civil rights complaints against D.C. officials for failing to meet Rule 8 pleading requirements and being barred by various immunities, including sovereign and judicial immunity. In the 11th Circuit, the court affirmed a dismissal with prejudice and the entry of a filing injunction against James Dowse as a vexatious litigant. The court found his complaint was a shotgun pleading replete with conclusory facts that failed to provide adequate notice, and the district court did not abuse its discretion in classifying it as such after prior opportunities to cure were given. In the 9th Circuit, the court affirmed a dismissal of claims against web group Czech Republic under Section 230 of the Communications Decency Act. The panel held that treating the platform as a publisher for third-party content would impose an illegal monitoring obligation, and their use of neutral tools like algorithms did not materially contribute to creating the unlawful content. Finally, in a high-stakes affirmation in the 9th Circuit involving student borrowers suing loan servicers under RICO, the court held there was sufficient evidence that plaintiffs could not have reasonably discovered the fraud more than 4 years before filing. The clock started only after ITT Technical Institute's collapse and bankruptcy in September 2016, satisfying the injury discovery rule for the statute of limitations. Back to you, David.
Thanks, Aisha. Let's turn to Michael covering Supreme Court and constitutional law.
Thanks, David. I have 4 substantive cases for you today from the 3rd and 9th Circuits. The disposition roll-up shows 1 vacatur and remand and 3 affirmances. Starting in the 3rd Circuit, Brandon Timmons v. Bohinski was vacated and remanded. The court held that the district court erred by rejecting the plaintiff's pro se declaration, asserting that prison officials intimidated him into not filing administrative grievances. This intimidation rendered the exhaustion process unavailable under the Prison Litigation Reform Act. The panel clarified that while defendants bear the burden of proving failure to exhaust, a plaintiff claiming unavailability must provide specific facts rather than conclusory statements, and found Timmons's declaration sufficient to create a genuine issue of material fact. Moving to the 9th Circuit, 3 cases were affirmed. In Duden v. the State of Washington, the court upheld summary judgment for the Department of Corrections on failure to accommodate claims under Title VII in state law, applying the standard from Groff v. DeJoy. The panel determined that accommodating a religious objection to a COVID vaccine mandate would impose an undue hardship because 30% of Duden's duties required in-person instruction of inmates in a high-security facility where internet access is prohibited, and alternative protocols failed to prevent significant disruption. Also affirmed in the 9th Circuit was Ahmed Al-Nouri v. Rubio, upholding the denial of a habeas corpus petition and the certification of his extradition to Iraq for premeditated murder. The court found competent evidence supported the probable cause determination that Al-Nouri conspired in the murders of 2 Iraqi police officers in 2006. Finally, Granados v. Breitenbach was affirmed regarding the denial of a federal habeas corpus petition challenging state murder convictions. The 9th Circuit held that the Nevada Supreme Court's rejection of sufficiency of evidence claims was not contrary to clearly established federal law under Section 2254 of Title 28, finding that rational triers of fact could find guilt beyond a reasonable doubt based on trial testimony regarding Granados's feud with the victims. Back to you, David.
Thanks, Michael. Now for business and civil law, Maria has the rundown.
Thanks, David. 4 cases on my desk today. 2 were affirmed in part and reversed in part, and 2 were affirmed in the 11th Circuit. The court affirmed a bankruptcy decision allowing attorney fees as an administrative expense payable from undisbursed funds even after a Chapter 13 case was dismissed before plan confirmation. Moving to the 4th Circuit, the court affirmed the dismissal of Saloma Johnson's complaint against Brooke Army Medical Center, applying the FERS doctrine which bars service members from suing the government for injuries incident to service. Over in the 8th Circuit, the court affirmed the dismissal of Shamrock Hill's facial challenges but reversed and remanded its as-applied First Amendment claim regarding Iowa statutes regulating public adjusting and prohibiting residential contractors from acting as adjusters. Finally, the 9th Circuit affirmed in part and reversed in part a summary judgment in a securities dispute, ruling that the district court erred in dismissing the trade secret misappropriation claim for lack of causation evidence under the California Uniform Trade Secrets Act. Back to you, David.
Thanks, Maria. Now Raj with immigration and government cases from the 10th through 9th Circuits.
Thanks, David. 12 substantive opinions in this block, 1 reversal, 1 split outcome, and 10 denials or affirmances. Leading with the movement cases, the 10th Circuit reversed and remanded Friends of Animals against the Fish and Wildlife Service, holding the agency acted arbitrarily under the Endangered Species Act and National Environmental Policy Act by failing to compare habitat biological value in its Utah Prairie Dog Conservation Plan. Over in the 9th Circuit, a split outcome occurred in DeVos Multimedia v. Antrix Corp., where the court affirmed confirmation of an international arbitral award but reversed on shareholders standing to register the judgment under the Foreign Sovereign Immunities Act arbitration exception. Turning to denials and affirmances, the 10th Circuit denied relief for Marquez Cortez against Bondi regarding asylum claims based on witness-to-crime social groups, finding they were not socially distinct. The 11th Circuit denied a petition by the Center for Biological Diversity against the EPA regarding Mosaic Fertilizer's phosphogypsum road project, upholding the agency's Clean Air Act compliance. In the 4th Circuit, the court denied Cindy Paz-Pineda and her daughter's asylum and Convention Against Torture claims against Blanche, finding substantial evidence supported the agency's adverse credibility and persecution findings, while simultaneously affirming the denial of Social Security disability benefits for Kellyanne Rainerson against the commissioner. The 7th Circuit denied Frank William Bonin II's challenge to a permanent FDIC ban, ruling that the statutory enforcement action involved public rights rather than private common law claims under the Jarkissi framework. Back in the 9th Circuit, Chun Yu's asylum petition was denied against Blanche due to adverse credibility findings, and Eufrasio Herrera's similar appeal was also dismissed based on substantial evidence supporting the agency's credibility determinations. Finally, the court affirmed the denial of Social Security benefits for Clyburn against Bisignano, rejecting the argument that vocational expert testimony conflicted with the claimant's residual functional capacity limitations. Back to you, David.
That wraps today's broadcast on Wednesday, August 12th, 2026. Thank you to James Taylor for covering 18 cases, Aisha Johnson with 10 cases, Michael Reeves with 4 cases, Maria Santos with 4 cases, and Raj Patel with 12 cases. The most significant outcome from the docket was 1 reversal or remand decision. 35 cases were affirmed, 7 were dismissed on procedural grounds, and 5 other dispositions concluded the day. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Please subscribe and follow for tomorrow's update.